And welcome back to the Law News Network. We are following the Henry Segura trial live, and I'm joined here in studio by Tom Ruskin. He's a private investigator and worked for the NYPD for more than 20 years, and Ronn Blitzer, who is a former prosecutor in the Brooklyn DA's office and works here at Law News as an editor. So, Ron, first of all, you've been following the Segura trial. What's your takeaway from what has happened this morning? What do you think is the most critical piece of testimony that has surfaced so far?
Well, I think the defense took a blow yesterday when the judge ruled that they couldn't get in as much evidence as they would have liked about their theory that someone else committed the crimes, that Mr. Santos had said in prison that it had been taken out on Peters and her family. But the witness here today, Darius Mount saying, the neighbor saying that he saw another vehicle that he knew was not Segura's after Segura had already left the home before the murders. I think that really helps their cause and tries to do a lot to show that maybe this wasn't Segura's doing after all.
Right. It puts that possibility into your head that maybe someone else was there that night, because now you're thinking, whose car was that?
Right.
We're going to get to Tom. We're going to talk about the Dalia Dippolito hearing, which is coming up too, but we want to toss right back now because live trial coverage takes precedence over all. It is king here, and the trial has just resumed.
Encouraging people to lock up and keep their doors shut.
Right. There were several strings of break-ins in the community around that time. So, no, a lot of people were very cautious about being very secure in the neighborhood around that time.
Okay. Any follow-up, Mr. Prince? No, Your Honor. Any follow-up, Mr. P? I'm sorry, Ms. Dugan.
Yes, sir.
All right, you can step down.
Thank you.
Thank you, Your Honor.
Well, he's free to go.
Yes, sir.
Right.
Well, we'd actually like to retain him. He can leave the courthouse and go about his business, but just be available.
Be subject to recall. Next witness, please.
This time, Your Honor, the defense will recall Officer Candace Jernigan.
So we had a problem with that headset the other day. When we had a problem with that headset making noise. Oh, I thought. Okay. Somewhere we're getting some feedback. I believe you were previously sworn, were you not?
Sir?
You were previously sworn.
Yes, sir.
All right, you remain under oath. You may sit down, slide up the microphone, please.
Officer Jernigan, can you again spell your first and last name for the court reporter, please?
It's first name Candice, last name is Jernigan.
And again, I know it's been a while, but you were one of the first responding officers to 908 Saddle Creek, the victim's residence in this case, right?
Yes, sir.
On the morning of November 20th.
Yes, sir.
Did you, in the course of your police activities that morning, have a chance to speak to Monica Peters when she arrived on scene?
Yes, sir.
Do you recall Monica Peters specifically telling you that she had spoken to Brandy, as opposed to attempting to speak to Brandy, that she'd spoken to Brandy at approximately 10 p.m. the night before?
That is what she told me.
Thank you. I have no further questions for this witness.
Cross.
So you spoke to Ms. Peters the morning of November 20th, 2010?
Yes, ma'am.
And where did you speak to her?
Across the street from 908. It's on the corner of Saddle Creek and Gimli.
Okay. And about what time?
I have no idea what time it was.
What time did you respond?
I responded, I got on scene around 10:17.
Okay, so at some
So-
point after 10:17 you talked to her?
Yes, ma'am.
All right, and this is right across the street outside the home where her sister and her nieces and her nephew had just been murdered
Yes.
and found dead.
Yes.
All right. Safe to say Miss Monica Peters was pretty emotional that morning.
Yes, she was.
She was crying that morning.
Yes, and she was shaken. Yes.
All right, thank you.
Okay.
Redirect.
No, Your Honor.
All right. Any juror have a question on this subject? On this subject? Write your question down, please. Just, what's that?
I don't know if it's on this subject or not.
Well, it should be on this subject. Write it down, we'll decide. We got a sidebar? Bill. Bill.
So as we're watching the Henry Segura trial live, you're hearing testimony from the first responder. I have next to me Tom Ruskin, who's a private investigator who worked for the NYPD for more than 20 years. Tom, if you could just say, what is the order of what a first responder is looking for when they arrive on scene?
Well, it really depends on what they're responding to. If they're responding to shots fired or a possible dead body, it would be a different type of response. Different types of officers would go. The first officers at the scene, of course, are trying to preserve the crime scene at all costs, trying to, if it's a assault or a killing or attempted killing, you're trying to rescue any people who could be rescued. If the people are definitively dead or have been killed in the past, it's preserving the crime scene. It's basically calling for your supervisor and detectives, crime scene personnel, and anything else you may need to preserve that crime scene for eventual prosecution.
It could get complicated though, right? Because if you are at the same time thinking of potentially rescuing someone or searching to see if anybody's in there that you may not know about, and also preserving the crime scene, that can get a little bit tricky. It's almost like you have to tiptoe and run at the same time.
That's exactly right. I mean, that's a very, very good question, because sometimes you may have one victim who's still alive where others have passed on. And at that point in time, you're thinking about saving that one person at all costs. And sometimes you do disturb or basically destroy a crime scene by what you have to do to save somebody. If it's a definitive homicide, like in this case, where you have 4 deceased, at that point in time you're notifying the DA's office as well. They're going to respond the DA on call to be able to work through with detectives and cops and supervisors what has to be done to preserve that case for the DA's office.
Yeah, it's a tricky balancing act.
Well,
basically.
it's not only tricky, but there's also a checklist that cops go through.
Perfect. And now we're gonna listen in on what this first responder has to say.
And did she say what number she used to make contact with her?
No, sir. I had asked her at some point if she had a cell phone, if Brandy had a cell phone, but that's the only discussion that we had about the phone.
And you may or may not be able to answer this question, but when canvassing the area of a crime scene, do you know how it is determined how large of an area to canvass?
As far as on the external part of the house or the internal?
Talking about the neighborhood, what we're talking, canvassing of the neighborhood.
I mean, I can just tell you what I overheard.
But the
People
question
saying,
is,
yeah, I
in
don't-
general, do you know how that is determined, how wide of an area to canvass?
No, sir. But this type of situation, I know we went and talked to neighbors, but no, sir, I couldn't specifically say since I was the first responding. I was busy with the scene and interviewing.
Okay. All right. Any follow-up, Mr. Prince?
No, Your Honor.
Any follow-up, Ms. Dugan?
Did Monica Peters ever give you any indication she talked to Brandy in any other way other than Brandy's cell phone?
No,
And canvassing the neighborhood, would that normally include the house right across the street?
canvassing as far as just speaking, trying to find witnesses. Yes. Yes.
Anything further?
No, Your Honor.
All right, we need to keep this, well, let's do this. Let's let the jury step out. We're about due for a break anyway. Let the jury step out.
So that's the Segura trial that we are watching live. This is a man in Florida accused of 4 counts of murder of his girlfriend, her twin children, two young girls, and another child that he had with this girlfriend, and faces the death penalty. But I want to switch gears for a second, because at 11:30, what's coming up is the Dalia Dippolito hearing, and basically what she's asking for, this woman in Florida who was convicted of hiring somebody to kill her husband. Well, now she is asking that while she appeals the conviction, she wants to be freed. So basically, I'm here with Ronn Blitzer, who is an editor at Law News, former prosecutor in the Brooklyn DA's office, and Tom Ruskin, who is a private investigator, manages his own firm, and has defended some pretty important dignitaries, worked with the NYPD for more than 20 years. Ron, let's go to you first. What do you think is Dalia Dippolito's chances of being freed while she appeals this conviction?
Well, I don't think it's great. Sure, it took a long time to actually get this conviction. This was the 3rd trial. Yeah, she was convicted the first time, and then that was vacated, and then there was a mistrial, and
yeah,
now
but
finally...
interesting fact, Ron, on the first trial, after she was convicted, she was freed on bail.
Right.
For 7 years while she appealed.
Yeah, so, we'll see what the judge ends up deciding. If it was me, I wouldn't do it.
Why?
This was, just from the nature of the crimes, I always have that, as one of the key elements. When I was a prosecutor, there are a number of factors that you weigh when determining whether or not someone should be kept in or not. Mm-hmm. Sure, flight risk is one of the main ones, and yes, maybe she's not the biggest flight risk right now. As you said, she was released from that first conviction.
She has that history where she can say, I didn't do it before, I won't do it again.
But at the same time, the nature of the crime, plotting to have your husband killed, maybe it's just the prosecutor in me trying to come down harder on someone, but I would want to push to keep her in.
I agree with you, but I'm sitting here, I'm scratching my head reading this motion for appellate bond, and I'm looking at the factors here. And the factors, when the court's deciding this, are flight risk, the nature of the appeal, whether there are actual substantial issues there that can be debated. But I don't see anything in here where the court determines, well, if somebody tried to kill their husband, they shouldn't be released. I mean, it says if there's a capital felony, then they shouldn't be released. But why are there exceptions when someone tried to kill their husband? Why should they be free?
This is a woman who hired an undercover cop, unbeknownst to her, to kill her husband, and was told that the homicide had happened, that the person had killed him. She was under the belief that she's already been in jail. And to Ron's point, which I think is a very good point as a prosecutor and ex-cop, I think the point is that you have the possibility, now that she's been in jail, she is more of a flight risk. Mm-hmm. That's the argument. And what is her chances of prevailing at the appeal? I don't know what the issues are underlining, but she's already been in jail. So to me, she's more of a flight risk. The possibility is, I think that the case was pretty strong against her. We can talk about entrapment and stuff like that later, but the case was pretty strong enough to convict her,
right,
that she now has to go for an appeal.
But I mean, flight risk, okay, let's put that aside for a second. Mm-hmm. She was convicted of solicitation to kill her husband. How do we know that she's not still dangerous? I mean, is the question to me, is this a dangerous woman? Flight risk, fine, it's great. She shows up to court. They can hold her accountable. But what about the public? What about all us? Right. Do we want somebody like that out after she's been convicted of trying to kill someone?
Correct. Not only try and kill him, but she tried to hire the person on tape, and the tape was revealed. I mean,
red-handed.
It was sort of a glorified type of case because the police had all the video and then told her that they had done it. Well, the person she had hired, she believed killed him. And that was taped. I don't think that she has a very good chance on appeal. I don't think that the police did anything that was misconduct in this case.
But as a police officer, do you think it should even be a possibility that someone who's been convicted on solicitation of murder should be free during an appeal?
I think you have to look at, I think that we both would agree, you have to look at the underlying facts of the case. You have to determine, does she have a very good chance of prevailing at her appeal, either to get a new trial or to have it just thrown out? And then decide on the case itself. In a case like this, no, she shouldn't be out. She's going to be convicted. The appeal is going to go down. She's going to serve her time. She should be serving her time in jail. To me, she tried to kill one person. So to your point, which is a very good point, what stops her from trying to kill someone else, including the potential witnesses against her?
Right, but then just to play devil's advocate on you, it sounds like you're making
like attorney?
Right, sounds like you're making a summary judgment right now. Well, we're going to decide, and Ron, maybe you can weigh in on this. Well, we're going to decide whether she's going to be successful on her appeal. How can you ever know? And so, because she is appealing on substantial issues, one of which is whether it should have been admissible that she tried to poison her husband. I think that it should have, but the question is, the reason why it's all debated is because initially the prosecution stipulated that they were not going to admit that, and then they changed their mind and the judge allowed it in. So that's a substantial issue. But the question is, does that matter when you're talking about somebody being freed after they're convicted? How likely they are to win on the appeal?
Yeah, I mean,
can you ever know?
You can't know for sure, but issues like that come up all the time. If there's a preliminary injunction in a case, if you're trying to, if an appellate court wants to, stay a lower court's decision, they'll think, okay, well, what are the odds that the person moving for the stay will win on appeal? And they'll try to give, some sort of analysis there before the issue is actually decided, to decide whether or not to do anything at that point in time. So I think similar issues and similar reasoning come into play here. However, I do think, as you were saying, I think that the prosecution had a very strong case here. I don't see any strong reason for her to win on appeal. She's convicted of a heinous crime. She's in jail. I think she should stay in jail. Sure, the defense could argue this was a personal relationship between her and her husband, and this crime was specific to that relationship. She's not a serial killer. She's not going to go doing this to strangers. She's not a danger. But
that's
how
an
do you
interesting
know?
Analysis.
How do you know? This is someone who tried to have one person killed. You don't know what they're going to do on the outside. And as you mentioned, she's in jail, which would make her more of a flight risk if she doesn't want to go back.
Right, and we know that she does have a child at home who she had on house arrest, so there is some incentive there. But I want to go through some of the issues that she's raising on appeal so we can kind of do that analysis. I mean, the first one is that they let in the fact that she tried to poison her husband on another occasion. To me, it sounds like that would be relevant in a solicitation to murder case, but let's put that aside for a second. The next one, because we know the answer to that, right? The next one, that a juror was sleeping during the testimony. Is that a viable issue on appeal, and do people usually win on that?
I've seen judges sleeping during trials, so no, I don't think that that's going to be grounds for an appeal.
I can't tell you how many times I've seen jurors sleep during the trials. The third, and you can weigh in on this, Tom, is that she was not allowed to present a defense of objective entrapment, that basically she was entrapped by the police. Is this something that you guys are trained on, to try to avoid entrapping somebody while still operating a sting at the same time?
The answer to your question is yes, but depending on your level of training and your level of assignment, the training would be much more intense for a detective or an undercover versus a street cop. Street cops very rarely would have the ability or the situation arise that would allow them to entrap.
Okay.
I mean, basically, but
they're not really going to put a street cop, right?
But a detective or an undercover detective would have more of an ability to entrap or possibly have that defense thrown at them depending on the case that they're dealing with. So
Got
let's
it.
say, for argument's sake, you have a guy in an interrogation room, and you're interrogating him, and you're telling them things that don't exist. The courts in New York have basically found you can tell them anything you want to tell. There's no such thing as entrapment based on a lie that you're telling the person. You can tell them that 3 people have told us that you did it. I have the 3 people, they're giving statements outside, sometimes they're even looking through the window, and you say that person right there is writing a statement. That's not considered entrapment in New York State. Other states have found the same, but that's not considered entrapment because
Is
if
that
you didn't do it,
coercion?
they say no.
So
They
what
say
is
no.
coercion?
Would a defense attorney or good defense attorney potentially raise it, especially if he or she could get in front of the jury? I'm sure they would. But judges, like in this case, did not allow it.
So what constitutes coercion usually? Like what, as a cop, you're going into an interrogation room, what are you going to stay as far away from as possible?
A beating.
Okay.
No,
but anything short of that
you're
is
saying
fair
that
game,
would
right?
be coercion.
Right.
If you beat the person and you under duress keep the person up for 42 hours without giving them a bathroom, food, water, stuff like that. That's why in major cases, capital crimes, in our state and every state that I know of in our country, you have a DA with you. You have a DA working hand in hand with the police, telling the cops, all right, let's do this. I'm okay with that. If the cops run by a DA, so I would turn to Ron and say, listen, this is what we're thinking of doing. Are you okay with it?
Yeah, but Tom, what about all of these instances where we see the cops saying what happened during the crime and leading the person to agree that it happened?
Well,
Instead of the person confessing, because then you don't know whether that person actually was there and what they're saying lines up with what actually happened, or whether they're being fed it, basically, by the police department.
Well, I mean, every cop that I know of tries to solve a crime the best way that he or she knows. And they basically try and get a confession from the person that they know committed that crime. Short of the things you're not allowed to do, like hit a prisoner, deprive a prisoner of sleep, or not afford them an attorney if they so desire under their Miranda rights, you can get a confession. And if you can convince the person that you know enough, you don't want to lie to them, because if you're telling them a lie and they know it's a lie, they know you're full of crap.
Right, but
So-
what about, like, Ron, what about with Brendan Dassey in Making a Murderer? You have a young guy who they're asking him the details of the crime. He doesn't seem to know. Then the police start sort of leading him to what happened, basically saying what happened. And he's an impressionable person, allegedly with a low IQ, wanted to get home to watch WrestleMania. I mean, what about these instances where you have young people who are in there and the police are saying, well, come on, tell me what happened, and they don't seem to know it. You stabbed her, didn't you? Oh yeah, I stabbed her, because they want to get the heck out of there. They've been in there for 10 hours straight.
Right. So that goes to what you were saying about, other factors and doing things that you're not allowed to do. If you are detaining someone for so long as a method of trying to pump information out of them because they just want to get out of there, then that's problematic. And with Dassey, his youth, his, the issue of his, mental development was brought up at one point. Those are additional factors, but just leading questions, are not enough to be deemed coercion, because you're providing information, but that person ideally is consensually agreeing to what you're saying. Once that's no longer consensual, then you have a problem. But if you're leading a question, same if you're doing cross-examination, you're leading a witness and they're saying yes, 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 and just saying, what you want them to say, hopefully. For a police officer to ask a leading question just to get information, that's fine. Because one, it shows if the officer is being truthful, or even if he's not, but if he's playing off of a hunch, then he's providing information showing the suspect that he may know information that the suspect didn't think that the officer knows, so he's going to be more forthcoming. Or, the suspect will see, they have me, I'm just going to go along with this because they know what's up.
Right.
So
Sometimes
just
it
saying-
works, sometimes it doesn't.
Exactly.
Though, right?
Just saying yes or no to a leading question is fine.
I would disagree on one point. When somebody's up there on the stand, they are heavily, heavily prepared by their lawyers about what's going to unfold. Very different from taking somebody off the street, especially with young people who don't even know what the heck's going on. But you're right, sometimes it works. Obviously, sometimes it doesn't. With Dalia Dippolito, again, today she is going to be petitioning the court that she be freed on bail while her appeal pends on her conviction for solicitation to murder her husband. So, Tom, she's saying that she should have been allowed to bring this objective entrapment defense. So here's what she's saying, that Shehadeh, and this is this former boyfriend of hers who went to the police and basically ratted her out and said, this woman wants to kill her husband, and then he participated in the undercover operation before she met with the police officer. He sat there and they recorded her telling him that she wanted to meet with this police officer to hire him to basically kill her husband. So it's saying that first this guy, Shehadeh, approached the police department to report domestic violence, not to report this murder for hire plot. And she's alleging that her former boyfriend was tricked into cooperating and basically threatened with prosecution if he didn't go along with the sting operation. Does this happen?
No, I wouldn't say it happens in that terms, but if the police believe that a crime may be being committed, you can't talk someone, see, this is where I go back to my cop hat. You can't talk someone into robbing a bank if they're not going to go into that bank and pull a gun or hand a note robbing the bank. It'd be a different thing if the person had a defense and said, listen, the guy outside gave me this envelope, I didn't even know what was in it, and when you opened it up, the crap hit the fan, I didn't even know what was in the envelope. If you go up and it says on the envelope, this is a robbery, and you hand the person the note and say that someone outside, you have to convince 12 people that that person's guilty. They convinced 12 people that she was guilty, she was convicted, she went to jail. Now she's trying to get out of jail, and I don't blame her because jail is not a great place to spend the summer or your winter or your fall or your spring.
But you're saying the video should be enough. Caught red-handed, it should be enough?
I think it's the totality of the evidence. I think she definitely tried to hire an undercover officer. She tried to hire someone that she didn't know was a cop to kill her husband. And she believed that he did it.
But she's saying that the police, and I'm quoting her appeal here, manufactured a murder for hire plot. The police manufactured it, not her. Instead of investigating this complaint about domestic abuse, which is what she alleges why her ex-boyfriend went in there.
She's going to have a very difficult time since she's heard on audio and videotape of hiring the person, negotiating a fee, and believing that the person carried it out.
Now she's saying she thinks that they manufactured the plot because it was influenced, and we talked about this, by the presence of the show Cops. And I'm quoting again, it explains why there were planted cameras in this guy's car without his consent, and why the police created an artificial 72-hour deadline for the completion of the investigation. Are there deadlines in investigations, and is this a valid argument, would you say?
It's an argument. I don't know if it's valid. Listen.
Do you say within 72 hours I'm going to complete the investigation?
Defense attorneys at times, especially appellate defense attorneys, throw crap against the wall and they hope something sticks enough that a judge will dismiss the original charge and possibly send it back. That's all they have. It's that
not just sticks but
or
smells
jail.
like roses, right?
What?
Not just sticks but smells like roses and isn't actually crap.
Originally it has to stick, then it starts to smell on the wall over time. But, basically what she's doing is she's throwing crap against the wall. She's hoping something sticks. Her attorney's hoping to either order a new trial or dismiss the whole case in total. It's not going to happen. She was caught on tape trying to hire someone to kill her husband and negotiating a fee and believing that that person carried it out. Had she known it was an undercover cop, she would not have negotiated with him.
Okay, how about this though, Ron? It worked the first time. She was convicted and it was overturned on a technicality, despite what Tom is saying, all of this evidence of her being caught red-handed, saying she wants to pay thousands of dollars to have her husband killed.
It worked the first time. It shouldn't work. It shouldn't have, and it's not going to work this time. I mean,
Were you shocked by that?
yeah. I mean, the idea that something on reality TV isn't entirely made up of reality is nothing new, but the idea that this was all manufactured is bogus. I mean, the thought, what they manufactured her side of the conversations. They manufactured her negotiating with someone who she thought was a hitman.
Well,
and
at one
agreeing-
point she said she was an actor in a reality show. Do you remember that defense that failed miserably?
Yeah, and it failed miserably. So if they try it again, it's going to fail miserably again. It's a load of garbage. To think, yes, reality TV isn't always real, but this isn't The Bachelor. This is Cops. It's different.
Okay, so Tom, she also says
She got the rose, which was her time in jail.
She also, and thank God he wasn't killed. I mean, we wouldn't be
Yeah.
sitting here giggling, right?
Had
But
it not been an undercover cop, and this was a true murder for hire plot, he'd be dead. The police would be investigating a homicide, potentially lock up the hitman, because eventually they do solve the majority of crimes that occur in this country. And at that point in time, she would have been arrested, because trust me, the hitman's not going down alone. He's taking her with him.
right, and I think that was also the impetus for the ex-boyfriend because he didn't want to be implicated, and maybe that's why he went to the police in the first place. But what do you think about the involvement of this show, Cops? What's your personal opinion on that as former law
What
enforcement
is
officer?
my personal opinion of cops?
Of filming these investigations,
I'm not in
real-life
favor.
investigations. You're not.
No.
Why?
New York City Police Department does not cooperate with reality TV shows, with ride-along TV shows, because too many things can go wrong. First, you can get your officers hurt or killed because they may react differently because there's a camera crew. They may get hurt differently because there's a camera crew lighting them up at the point in time when they're taking police action. The New York City Police Department has a policy that they will not cooperate with these type of reality TV shows. They don't believe
But
that
they're the
police work-
minority.
I would disagree with that. There's a lot of departments around this country, major cities and departments that do not cooperate. You find smaller sheriff's departments and smaller departments that are more cooperative of that.
But not the major cities.
The major cities, for the most part, have not cooperated in reality TV shows. They'll have a news crew with them to show what police work is like or what a specialized unit's doing. That's fine. But they don't have them riding around. There was a case recently, I think it was out of Florida, where a reality TV show was following, it was live, slight delay, was riding around and responded to a homicide. Dead bodies there. The people at home who were watching the reality TV show saw their loved one as the deceased. And that's the way that they got notified.
You know
That's
what?
not what this country's about.
Yeah.
That's not what reality TV show is about. You want to pick, Bachelor number 1, Bachelor number 2, or Bachelor number 3, and you want to go on a date or get engaged after 20 weeks, that's fine. But police work is real life and death situations where cops are responding to try and save people or try and stop a crime in progress from some very bad people that are out there. It's not a matter of watching it at home with your popcorn and your soda.
But unfortunately, Tom, I mean, that's the culture that has evolved, not just with police work, but in all areas.
Right.
We're seeing a lot of things going on in people's real lives that maybe we shouldn't see, but people love it. I mean, they eat it up. But on the flip side of that, what about it being a check on the police officers? Very much like, listen, we're in the courtrooms. I bet you a lot of lawyers and judges have and they will say that we should not be live streaming trials. Cameras shouldn't be in the courtroom. This is an ongoing debate. But obviously here we support it. We feel that it's a check on the system. Is there a similar check on the system when you're following police officers where maybe you're not going to see police officers shoot when it's unnecessary or unjustified or do a search and seizure when they don't have probable cause? Is that a viable argument?
Yes, and law enforcement agencies, governmental agencies have taken the steps to solve that problem. To your excellent point,
Thank you.
cameras are now, police officers are now wearing body cams, that they're recording everything. We've had cameras on the front of police cars for years and years and years. So as soon as you put on your lights, or nowadays, because the capabilities of those cameras are so great and so capable of taping a myriad of days, You can keep it on constantly. We are recording everything. And with the eyes in the skies all around different cities, you're capturing every single thing. Police departments around this country now are solving the majority of their cases, where it's not solved immediately by responding patrol, by cameras of neighbors and friends and stores and other people who are recording every single thing that's going on.
Yeah.
Whereas years ago, when I started as a cop in the 80s, there was no cameras. I mean, a camera was a big thing that someone carried, and you could pretty much determine that they were tourists walking around Midtown Manhattan.
Yeah.
But the camera was tremendous. Nowadays, everyone has it in their phone. Everyone's recording stuff. So, to your point, we don't have to have reality TV shows following cops around to see what happened. Cops have recently been prosecuted in many different states for crimes that they committed on tape with their own body camera or something else. We have another police department now, which will go unnamed, which is under scrutiny because cops supposedly may have planted drugs and or contraband to arrest the person that they were questioning, all on body cam tape.
So they have the body cam and they're still doing it? I mean, that sounds a little bit ridiculous, right?
Sometimes they're I mean, in this one case that I'm talking about, out of a major city, their partner's body cam was running
Caught the other
and
guy.
caught the other guy. And that's what we have it for.
Right.
That's what listen, no one wants a dirty cop. No one wants a cop that's not doing something to hoil by the
You
book.
only want a dirty cop at a bachelorette party, basically.
Well, maybe, or, maybe, going after the bachelorette.
no, right, but to your point,
Oh,
yes,
you the rose.
Yes, exactly. You get there. I think Tom is destined to walk away from this on-air segment here with a rose, basically. But
yeah, maybe.
yes, to your point, these cameras do provide a check, and they also, Ron, like he said, serve as evidence. But what about the Tensing trial we just covered? This person, there was an argument that he unjustifiably killed somebody at a traffic stop, and he was not convicted, and it was caught on body cam. And the reason I'm bringing that up is because Tom said, listen, yes, people are going to have a check on them if they have the body cam, but a lot of times someone may act differently and more professional if there's a camera crew there, more so than if they have the body cam on.
Yes, that's certainly true. If there is a camera crew there, maybe they'll act differently for the cameras, knowing that a wider audience is going to be watching. But I do agree to an extent with the point that it can get in the way and it can compromise an investigation somewhat. That being said, there is value to having cameras following around on some of these shows because, yes, while police do have body cams and they do have dash cams, the general public usually only sees that footage when something bad happens, when a cop does something wrong. And I think that feeds into the distrust that a lot of American people have for police officers. So I think when there are TV programs that show police officers doing their jobs properly and well, it restores some of that trust.
That's interesting. Would you agree with that, Tom? Does he get the rose?
No, he doesn't. He gets a portion of a rose. It's a short-stemmed rose. My response to that would be, you can see it on the body cam as well. There was just a recent video that I posted on my Facebook page in which cops down saw a woman who had had her purse ripped off in a grocery store. And this had millions of hits.
Right.
And what the cops did is they talked to the store owner on body cam and said to the store owner, would you be willing to give her groceries? She just had all her money stolen from her. She's on food stamps and she just doesn't have the money to pay for it. The grocery store gave her
Oh, that's nice.
the $80, $90 worth of groceries she was planning to buy before her purse was stolen on a camera.
Right.
You saw the people who stole it. And then the cops came back because other people had donated things to her. And you see it all on body cam. And it was posted on the web for people to see. That's the purpose of the body cams as well.
Right.
I don't need a camera crew in my back that I have to worry about their safety if we get involved in the shooting. Even though we have the indemnification forms, And I don't need them to record what I'm going to do. I'm going to do my job as a cop. And every single cop out there is doing their job every single day, risking their life. They don't have to worry about a camera crew. And we don't need a camera crew to say the great work that police do. Neighborhoods know, people know, communities know the great work that police do around this world.
Though some people who are police officers do love that, that little bit of gratification. But
It's a good thing.
Yeah.
I mean, cops do good things every single day.
now let me ask you one last thing, and then I think the Dalia Dippolito hearing is about to get underway. Here's another quote from her appeal that basically this motion says, Mrs. Dippolito says that the police never believed she was actually going to kill her husband because they were joking during this whole cops filming, and they failed to conduct surveillance on Mike Dippolito. Is that a viable thing? Listen, somebody goes into the station and says this woman's going to kill her husband. They catch her on tape saying she's going to kill the husband, but they're not watching out for the husband's safety to make sure that she didn't hire somebody else or she doesn't go try to do it herself. Why didn't they surveil the guy?
Well, I don't know what they did to protect Mr. Dippolito during the case. I definitely would have put some kind of safeguards in place for him if it was my case.
What about the joking? That they're joking during the filming and the taping and having fun with it? Does that show that they're part of this reality scheme to concoct a murder plot?
You want to know something? What people seem to forget, and what Ron will know, we're all human beings. We all have our high moments and our low moments. We're seeing terrible things. As a cop, you're seeing terrible things every single day. And if cops have a tendency to kid about things and become comedic about terrible things that they see or that happen, that might enrage somebody who doesn't understand it. I mean, DAs do it too, but we won't give them up.
That's for sure.
But, you know, and cops and DAs have this sometimes sixth sense of humor.
Why
Is
is
it
that?
right?
Is that a coping mechanism because the job is just so draining? You're seeing terrible things day in and day out. Yeah, Ron, go ahead. Why are you joking about people's tragedies over there? And it happens in the news business too.
Oh, absolutely. You know, I'm guilty of it myself when I was a prosecutor. It happened all the time. You know, when your daily routine involves things that are objectively horrible, you become desensitized to a degree. Not to the extent that you don't care about the cases. I mean, there were always cases that still got to me, even when I would see, you know, things on a daily basis that would startle most people. But it just affects how you think about crime. And yes, to a degree, I think subconsciously it probably is a coping mechanism to just make light of things when you have the opportunity.
Right. Okay. Thank you guys so much for your input. We're going to go straight now to the Dalia Dippolito hearing. And you're seeing it now live. As I mentioned, Dalia Dippolito is asking the court to let her be free, go home, spend some time with her little baby at home that she had on house arrest, while she appeals this conviction in a murder plot to kill her husband. She was found guilty of solicitation to kill her husband. And we've been talking about whether her appeal basically has a shot at all. So I'm joined here again by Tom Ruskin, who is a former NYPD. Tell everybody about your background, actually. You have a very interesting background. To just say that you worked for the NYPD.
I'm a legend in my own mind.
Right, and everybody else's. But for 20 years you were there, you did a lot of things.
Yeah, did a lot of things.
Like what? What are you the most proud of?
I mean, I'm proud of being able to serve the city of New York and being able to walk around and talk about it and promote police work and promote what cops around this country and really the world do to keep their residents and people who come to their city safe.
But you worked in the narcotics unit, right, with organized crime at one point.
Correct.
You were telling me that you responded to Sparks Steakhouse the night that there was
I was at Sparks when what we found out later was Sammy the Bull and John Gotti killed Paul Castellano and his driver. Yes, I was there then.
Fascinating. So you're an expert.
Well, it's fascinating until you're them.
Exactly.
And you're the victim of the crime.
Exactly.
I mean, listen, as a cop in a major city, you see things that are horrific. And you can Narcotics Division of the New York City Police Department, I saw people who were brutally murdered, and you deal with it.
And now we're gonna, Tom, sorry to cut you off there. We're gonna toss to this, very similar to Sparks Steakhouse, because that was a murder for hire plot, right? So now back to the Dalia Dippolito hearing, where she is asking to be freed while her appeal is pending.
In the third trial, the state did prevail, but it's our position that if you eliminate that first contaminated trial, right now we're at 1-1, and who knows where things would go if there would be another trial. So that first factor, I think, does still gravitate in our favor. The second factor I would concede to the state. The state makes an argument, well, she's been sentenced to 16 years, that's a lengthy sentence, and therefore she should be granted bond. If you take that factor alone, the state's got a great argument. We do agree that's a long sentence that the court has given to Ms. Dippolito, but that factor in and of itself is not going to be dispositive in Your Honor's ruling. I think when we get to the factors 3 and 4, this is where I think we have a really solid argument for the court granting bond. The third factor that the state mentions is does Dalia Dippolito have any meritorious claims for appeal? And the Florida courts have made it clear that the measuring stick for that is not, are we going to prevail? Is there a good chance we're going to prevail? But the fact, or the measuring stick, Your Honor, is it fairly debatable that Dalia Dippolito has a shot on appeal? And for the court's edification, I'm sure you're aware we have filed a notice of appeal. And, it's our position categorically that, there are 3 major issues that we will be pursuing on appeal, and I'm saying this respectfully because it is a bit awkward because Your Honor's already ruled against us on a new trial based on these factors, but I want to go ahead and mention these factors for Your Honor. The first one was the court admitting evidence of the allegation that Dalia Dippolito attempted to kill Mike Dippolito by using antifreeze, I believe, in a cup of tea. And it's important to note that both in the first trial, the trial judge in that case did not allow that evidence to be presented to the jury. That it would be very inflammatory under Rule 403. And then in the last trial that we did, so it'd be the third trial that we've done in this case, there was a pretrial ruling, and I believe the state had even stipulated that evidence would not come into trial in the last trial. And it wasn't until the last day of trial where the state came up and said, well, we want to try to get this into evidence as impeachment. The court did an offer of proof, and I believe that the offer of proof was a confidential form of Muhammad Shahade. It's our position, Your Honor, and we'll take this position on appeal, that what Shahade said in the offer of proof actually validated that it wasn't really true impeachment evidence. So it's our position that what he was saying on the stand didn't really contradict something that he previously said. With that said, we won't spend a lot of time on that. Let's move to the more profound argument, which is we could debate all day whether that was true impeachment evidence on the antifreeze allegation. But the more important point, we made vigorous argument in trial about this, was the 403 issue, which is what is the profound prejudicial effect on the jury going to be when you weigh it against the probative value of that evidence? And it's our position that a jury hearing about Dalia Dippolito allegedly trying to kill Mike Dippolito with antifreeze was a death nail. It was a death sentence in that third trial. So the prejudicial effect of that evidence clearly outweighed the probative value. That's the first major appellate issue that we're going to be raising. The second one was that issue, Your Honor, I'm sure you recall, the Riviera Beach evidence that came in. Again, for the record, I can't recall whether the state stipulated to that not coming in, but I know there was a pretrial in limine order that Your Honor had signed indicating that it wasn't going to be coming into evidence in the third trial. I don't believe the Riviera Beach, and what I mean by Riviera Beach was the allegation that Muhammad Shahade has spoken to somebody who has overheard Dalia Dippolito allegedly trying to hire a hitman that was named Larry was used to try to kill Mike Dippolito. I don't believe that evidence was even permitted in the first trial in which Dalia Dippolito was convicted. Be that as it may, in the third trial, up until the last day of trial, that evidence was not permitted to be discussed in front of the jury as well. The state then came forward and said, hey, wait, we're trying to use this as impeachment evidence again against Mohammed Shahadi. We didn't offer proof on the Riviera Beach allegation. It's our position on appeal that not only were there's several layers of hearsay, but it just wasn't reliable enough. There are a couple of things. It wasn't reliable enough, and that's one of the factors Florida courts look at. Is this evidence? I guess the state was trying to use it to show propensity for Dalia to want to try to kill her husband, but there still has to be a reliable foundation for that evidence. And I believe, Your Honor, if you recall, Mohammed Shahadi even said at one point, hey, this is street information, and street information is often unreliable. I believe he said that in the offer of proof. So it's our position that even if this wasn't true impeachment evidence of Mohammed Shahadi with respect to the Riviera Beach allegation, but even if there's a determination that the allegation of the Riviera Beach incident was impeachment, that again, the prejudicial effect of a jury hearing that Mohammed heard somebody else say that Dalia was trying to hire a hitman to kill her husband. Again, that is going to be an absolute death nail in the trial. The jury's not going to be able to get beyond hearing that evidence to hear the other evidence in the case that we were making about a police investigation that lacked integrity. The third appellate issue that we'll be raising, Your Honor, and we've already raised this before, Your Honor, is the allegation of one of the jurors sleeping during critical evidence during the trial. I'm not going to debate the entire issue again. I'm just going to, the only point I'd like to make is since I've last seen you, a member of the jury panel has come forward. Now, so again, it wasn't just affidavits that we had submitted from folks in the courtroom, in other words, observers in the courtroom. We now have, I believe it was an audio tape or videotaped interview with a reporter named Michelle Casada, in which this juror said, yeah, I did notice one of the jurors nodding off, and her eyes were closed, and that I believe a couple of alternate jurors had actually wake up the woman, I believe her name was Castaneda, the juror, during parts of the trial. So the court, I believe there may be a motion pending on the recent developments with one of the jurors coming forward. Putting that aside, we believe that is a meritorious appellate issue. Not only does the Constitution, the Sixth Amendment affords a defendant a right to a fair trial, hearing all the evidence. I believe there's case law in Florida too that suggests that if a juror is not hearing or not paying attention, critical evidence in the case, that is depriving a defendant of a fair trial. So those are three issues Your Honor will raise in an appeal. Well, why are they important in the scheme of things for this bond hearing? Well, the state has proffered, Your Honor, that this case is much like the Goodman case. I'm sure the court's aware of that case. And in the Goodman case, they parallel Dalia Dippolito to Goodman. They say, well, look at what the judge did in Goodman. He did not grant bond after the second trial. Now, a couple differences in Goodman versus Dippolito, Your Honor. One of them I just mentioned. That's why it's important to make that distinction. In Goodman, there really was no legitimate issue on appeal. There really was nothing meritorious that Goodman could raise on appeal. And fast forward to this case, Your Honor, it's not as if we're going up on appeal in this case, for example, on improper jury selection, because I think Your Honor did a fantastic job in both the trials that I conducted in selecting the jury. So we're not trying to, cover our eyes and put our hand in a hat and pull out, oh, jury selection, bad jury selection. Let's appeal that while we can get Dalia bond. We're not doing something like that because the judge did a great job at jury selection. What we're saying is there are three bona fide issues that I've just outlined that I'm not telling you whether we're going to win or not. We're hopeful, obviously. We will, but we think we have a reasonable, at least minimally, a fairly debatable chance at winning on one or more of those appellate issues. So this is not like the Goodman case on the appellate issues in Goodman. And then the final factor I'm going to mention, Your Honor, does dovetail the Goodman argument again. In other words, the state mentions Goodman and says do what they did in Goodman, don't grant bond. But the other difference in Goodman, getting to my fourth factor, is flight risk. That's another factor that the state mentioned, the factor that's considered by the courts. So was John Goodman a flight risk versus Dalia Dippolito? I mean, the trial judge, I think Mr. Williams had a task order from the trial judge in the Goodman case. He flat out said, hey, Goodman's got a lot of money. He's affluent. He also has family members who are affluent. He has the means to flee, the financial means to flee. That's a really profound distinction, Your Honor, from the Dalia Dippolito case. She's already been deemed by the court indigent. She has very little money. I haven't been paid. Her lawyers haven't been paid on this case. So she does not have the financial means to flee. More importantly, she surrendered her passport. And what better measuring stick for Your Honor to look at? Forget about everything I'm saying, or what Mr. Williams is going to say, or what Mr. Greenlee is going to say. Forget about that. Look at her behavior over the past 8 years, Your Honor. If she was a flight risk, she would have done something over the past 8 years in trying to flee. She now has, and I know Your Honor's already mentioned you can't, consider her child. I know you could consider her child in the sentencing hearing. I get that. But that it is important and relevant for the bond hearing from the standpoint of another issue the courts look at, which is, does she have any family ties in the community? And clearly, Dalia Dippolito's entire life is in South Florida. Not only is she very close to her mom and her younger sister, but her child. And we're not playing up the trial, Your Honor, to try to get sympathy for Dalia Dippolito. It's important to look at it from a legal standpoint, which is she has unwavering ties to that community. So for her to try to flee and leave the country and leave everything she's living for and breathing for, it is completely at odds with common sense. So please consider that as well, Your Honor. And then the last point I'm going to make on this analysis is where the state has brought up this issue of a jailhouse phone call, and it's arguably important from the standpoint of flight risk. That's the last factor we're talking about right now. Yeah, so the state brought it up and said, well, listen to this phone call. This proves that Dalia Dippolito is a flight risk, and I would argue that I'm sure Your Honor has listened to the phone call as opposed to just reading, the written transcript that Mr. Williams attached. And I think when you take a look at the entire 10-minute phone call and look at the full context of that jailhouse phone call, this was trying to orchestrate some fantastic plan to try to escape from jail. Granted, Your Honor, it was not smart of her to make a comment like that on a jailhouse phone call, knowing that call is going to be recorded. But I'll give the court and the state that concession. But realistically, you hear that whole phone call. I mean, it was the first few minutes. Dalia was talking about loving her child, loving her family, wanting to do some speaking. She didn't call up this guy James and say, hey, dude, I got a great plan. I just read this article. Let's do it. There's nothing in that phone call, Your Honor, where Ms. Dippolito is requesting or seeking. As the state said, she was enthusiastically trying to get this guy James to do something. That, respectfully, Your Honor, is not the truth if you listen to that phone call. There was nothing enthusiastic in Dalia Dippolito's voice. It was very monotone. The entire conversation, to me, sounded like it was later at night. Two people that sounded tired, especially this James guy. And Dalia Dippolito had a similar tone of voice pretty much throughout the entire phone call. And another important point about the phone call, Your Honor, there were gaps during the phone call. In other words, there'd be a discussion, then there'd be silence during the phone call. It almost struck me as if these two were strained to carry on a conversation. Because there was a break in the call, and then Dalia Dippolito says, randomly, I heard about this inmate in South Carolina escaping using a drone. So she just came back. And then she mentioned that this guy James kind of says something about, well, it could, it could happen or something to that effect. And then Dalia Dippolito did say, yeah, that sounds great. Let's get on it. Get me some wire cutters. She didn't say anything to that effect at all, not even close. In fact, she said, settle down. So, and then after that, Your Honor, last point I want to make about this jailhouse phone call, is after they had this short discussion, 10-minute phone call, maybe 45 seconds to a minute, they're talking about this South Carolina inmate. Then there's another gap in the phone discussion. And then they're talking about this guy James and his mom and church. And then she finishes the phone call by saying that Dalia is heading out to meet some women to read as part of this, I believe, a reading club that she was involved in. So I think when you look at the entire context of that 10-minute phone call, I trust the court's judgment in reaching a determination that that jailhouse phone call does not indicate that Dalia Dippolito is a flight risk. And the court makes that determination, and you look at the four factors I just discussed, combined with the 8+ years of good behavior by Dalia Dippolito on house arrest, I would ask that the court grant a modest bond in this case. Thank you, Your Honor. And I'd like to ask, Your Honor, at this time, if the court is inclined to have a hearing and make a ruling on this, the second motion for sanctions against my co-counsel. I want to briefly, if the court's inclined to do that, or just to defer hearing that until Mr. Rosenfeld is back in town.
I'm not hearing that today. Mr. Rosenfeld would have to be here.
Right, that's what I thought.
So that will be set off at a later time.
All right, thank you for your time, Your Honor.
Okay. All right, Mr. Freely, did you want to call witnesses?
Yes, Your Honor, please support. I'd like to call Dalia's mother.
All right.
And Your Honor, I appreciate it.
I'm not going to have her take the stand. She'll just stand at the mic. Please raise your right hand for me. Do you swear or affirm the evidence you're about to hear is the truth, the whole truth, and nothing but the truth?
Yes, I am.
Okay, put your hand down. First, please state your full name for me.
Ronn Mohammed.
Okay, you may inquire.
Thank you, Your Honor. Ms. Mohammed, how do you know the defendant?
She's my daughter.
Where did your daughter live prior to being taken into custody?
With me.
What is your address?
8132 Eastern Harbor Circle, Long Beach.
So that is within Long Beach County?
Yes.
Does your daughter, Mr. Dippolito, have any family that lives here?
Yes, she does.
Could you describe her family ties to the community?
My son, his wife, his son, my youngest daughter, myself, and my brother.
Does, if you know, Mr. Dippolito have any religious affiliation?
Yes, she does.
Does she attend services?
Yes, she does.
How often, if you know?
Twice a week.
Twice a week. How long, if you know, did Ms. Dippolito serve on house arrest?
8 years.
Did she ever express any interest in fleeing the jurisdiction of this court?
Not at all.
Over the past 8 years that Ms. Dippolito has been on house arrest, if you know, has she ever failed a random drug or alcohol test?
Not at all.
Has she paid the money that she owes on house arrest in a timely manner? If you know?
Yes, she did.
If she's ever had an appointment on house arrest, do you know whether she has filled out the verification forms that were required for her?
Yes, she did.
Every time?
Yes, she did.
Has she ever been late coming home from any appointment?
No.
If you know, when visitors have knocked on the front door for random house arrest home visits, has she answered the door?
Yes.
Every time?
Yes.
When house arrest randomly calls her, does she pick up the phone?
Yes.
Whenever house arrest has ordered her to visit the office of her house arrest, does Ms. Dippolito timely attend those visits?
Yes.
Does she leave immediately?
Yes.
Does Ms. Dippolito drive herself when she goes on appointments?
Yes, she does.
So she's unsupervised when she goes out in the community?
Yes.
Has Ms. Dippolito, if you know, ever received any type of speeding ticket or other infraction that would demonstrate disrespect for the rule of law?
No.
Does Ms. Dippolito ever perform any community services or outreach to the local community?
Yes, she has.
Could you describe those efforts?
In church, she has done quite few community helping on the services on Tuesdays. And she has also done some cooking for the homeless for the Palm Beach, the park in Palm Beach.
Do you know how often she prepares food for the homeless?
She has done it a couple of times.
Do you know whether or not your daughter is a registered voter in the community?
If she is, I'm sorry.
If she is a registered voter in the community?
Yes, I think she is.
Do you know whether or not she voted in this past election?
No, she didn't.
In your is your daughter a danger to the community?
Not at all.
Do you believe your daughter to be a flight risk?
No.
Thank you, Your Honor. I have no further questions.
Cross-examination.
The James that communicates with her on the jail calls all the time, tell the judge his real name.
Yes. Rob.
Robert what?
I'm sorry.
We would object on relevance grounds. We don't believe that this is relevant. In addition, it would require Ms. Dippolito to reveal the name of the father of her child. In fact, she would rather not disclose, and given the minimal relevance, we would object on it.
We didn't ask that question, just asked the person on the phone. What was the person's name on the phone? Since that's part of the state's presentation of the basis for denying bond and what impact or effect he may have on conditions of appellate release or release on bond pending appeal, I'm going to overrule the objection.
Robert what? Davis. And does Mr. Davis have a criminal history? You don't know? Okay. How long has Mr. Davis resided with you in your house?
A year. Okay.
A year? Okay. And he's the father of the child?
Objection, Your Honor.
I'm going to sustain the objection that it doesn't matter for this hearing.
Were you aware back in 2009 of any of the plots your daughter was committing? Planting drugs, pretending to be doctors, lawyers, trying to have Mike Dippolito killed?
Objection, Your Honor. Her state of mind is irrelevant to the issues.
Overruled because she's testified now based on direct examination that she's not a flight risk, and to her character, and the question becomes, what was her knowledge at the time? So overruled the objection.
Were you aware of any of that? In fact, when your daughter called you from jail and you saw on the news what was going on, did your daughter lie to you about what she had done?
No, she didn't lie.
She didn't lie to you, but so telling you she did nothing wrong, you thought that was truthful? you did. You've seen all the evidence and you still think your daughter did nothing wrong.
That's not how it happens.
We're following live right now the Dalia Dippolito hearing where she's asking to be freed on bail to go home to a young child that she had on house arrest while her appeal pens. She was convicted in the first trial that was ultimately overturned on appeal. During that time, she was at home for years, close to 8 years. I'm joined right now by Ronn Blitzer, who is an editor here at Law News and a former prosecutor at the Brooklyn DA's office, and Tom Ruskin, who is a private investigator with his own firm and a former NYPD officer. You served in several divisions for more than 2 decades. Ron, what do you think about her saying, free me, send me home? And we talked a little bit about this before. Do you think she will prevail? And we went over those arguments. Are they good arguments that they're making as to why she should be freed?
I don't think it's going to work, but again, that could just be wishful thinking on my part as a former prosecutor. We were talking about just the nature of this crime, how she was trying to have her husband killed, thought that she had succeeded in the plot. I would not release her, even though she was released in the first trial. There were reports that not too long ago, while she was in jail, she was discussing the idea of a prison break in a phone call. It wasn't necessarily a plan to actually carry out a prison break, but it was talking about a report of it happening somewhere else and how people were excited about it. So, I don't think that shows that she would actually do that, but it certainly doesn't help.
Do you think, Tom, that she's going to start her own reality television show in prison?
I don't think she'll be allowed to, but it's a decent idea. I think her trying the jailbreak is probably a more viable idea, even though I think her chances of succeeding are slim to none, especially since they all now know about it. There's a woman who tried to kill her husband and went to jail for killing her husband. Let's not lose sight of the crime.
So then what do you think about these technicalities then? Because you're saying that, right, let's not lose sight of the crime. And I agree. If you're going to meet the elements of the statute, which is solicitation to commit murder, they met that with those videotapes, right? They had her soliciting someone, handing over the cash, doling it out, giving pictures of her husband and saying, wipe my fingerprints off those pictures, and talking about that she's 5,000% sure that she wants her husband dead.
Correct.
Right? Okay, so that meets
and
the
elements.
elements.
And the fact that the cops come back to her and show her pictures of her deceased husband, supposedly killed, and her reaction.
So in one sentence, because we're going to go back to the hearing, in one sentence, if they meet the statute's elements, and in the first instance she's convicted, and it's overturned on a technicality because a juror was told something that maybe they shouldn't have been told and that evidence wasn't admitted, is that justice?
Well, justice was done. She's serving time for the crime.
But overturning on these technicalities, when it's clear the crime was committed.
We're not sure if they're going to overturn it.
The first time it was.
Yeah, but we're not sure what this court is going to do today.
Right.
So at this point in time, justice being served. She's serving her time for the attempted murder of her husband.
Okay, now let's go back to the courtroom and see whether she's going to succeed on this request to stay home while she appeals her conviction.
So the allegations he raised all were known to the court prior to her being given bond. None were charged, none were substantiated. We already established that she has strong ties to the community in addition to her family. Ms. Dippolito has informed me that a detective, Rodriguez, who works for the county jail, on Monday was assigned to investigate this jail call, has concluded that there was no evidence she's a flight risk. Mr. Dippolito has informed me that he would be willing to, the court would like to inquire, be willing to tell that to the court. Unfortunately, I just learned that last night. I wasn't able to get him to come today. That Mr. Dippolito is correct. I mean, he listened to the call and he independently concluded that she did nothing wrong by mentioning this. Among the other topics on different days that Ms. Dippolito discussed, I won't go through all of them. She wrote Donald Trump and the Russian scandal. So that's one topic of note. North Korea launching missiles. Scaramucci is fired. All these on different days. O.J. Simpson on parole. He's going to get out on parole after getting away with murder. The list goes on. Every day, it's public, current events. We would respectfully submit, Your Honor, that that's not evidence that she would talk about a highly publicized news article. It's, in my opinion, it's absurd to suggest that that is evidence that she would be flight risk. With that, Your Honor, we would ask for a reasonable appellate bond. We would specifically request an appellate bond that reflects that she is indigent. If the court is inclined to give a bond that's too high, it's tantamount to having no bond at all. And we would request that the court place her back on house arrest, pending her appeal with the same or similar conditions. Thank you, Your Honor.
Your Honor, this is Brian Claypool. I just have one final comment. I appreciate the opportunity. Actions speak louder than words. The past 8+ years of Dalia Dippolito on house arrest is the most powerful fact that we can show the court to warrant the court granting bonds. Contrary to what Mr. Williams said, if you agree with his theory, then Dalia Dippolito would have fled the country 7.5 years ago when she was on house arrest. Years of showing Your Honor that she does respect, putting aside all the evidence of the trial, she does respect the legal system. She hasn't plotted anything in the 8 years she was on house arrest. And certainly, it's much easier for somebody to flee from their home than try to flee from a prison using a drone. So I'm asking the court, please, take into consideration Ms. Dippolito's behavior on house arrest over the past 8 years. Thank you for your time, Your Honor.
All right. Probably disappointing to all, I'm going to take this under advisement. I have not granted or denied a request for an appellate bond after trial without writing a written order explaining my reasonings. And so I intend to do that in this case, no matter which way I go. I'm going to write a written order explaining my actions. So I will take this under advisement. I will issue an order. It will be timely. I won't wait long to issue it. I know everyone wants to know, particularly Ms. Dippolito, my ruling on this, but it will be in the order. With that said, we're in recess.
Watching Dalia Dippolito, a woman in Florida who was convicted on a solicitation to murder her husband charge. The third trial, the first she was convicted, the second there was a hung jury. Basically half of the jurors thought she was innocent. She has posed over the years all of these different defenses. First, that she was part of a reality program. Then in the next trial, she tried to do the blame the cops defense, that she was entrapped. In this third trial where she was convicted, she wanted again to blame the cops because it worked for her the second time, and she wasn't allowed to pose this defense. I'm joined in studio now by Ronn Blitzer, who's an editor here at Law News and a former prosecutor in the Brooklyn DA's office, and Tom Ruskin, a private investigator and former NYPD officer for more than 20 years. The blame the cops defense. How often does this work, Ron? The majority of times?
Not a lot. I mean, if there's egregious foul play, then sure. Or
like what? Like a coerced confession?
A coerced confession, or if, in cases where, evidence wasn't properly kept in the right, chain of custody, and, you could, create doubt that maybe evidence was tainted, sure. But, in a lot of cases, you don't really see it as much, and I don't expect it to work here.
Let me ask you something, Tom. Every time there's a trial, the blame the cops defense, this is a successful defense a lot of the times for these defendants. Why aren't all of the interrogations videotaped? If police officers know they are going to be called onto the stand to testify, their credibility, their memory is all going to be questioned to try to win for the defendant. Why did they take notes? Why do they sometimes not take notes instead of just tape recording these interrogations and confessions every single time?
Videotape confessions and videotape interviews and interrogations are being taped much more today than they were when I started in police work. Everything that we've talked about before, cops are much more recorded by body cams, car cams, and other cams than they ever have been before. So all this is going to come to task. Is it going to work for the cops? Not always, but then prosecutors, good prosecutors, are going to have to surmount those obstacles moving forward. But, there's no reason that anything that I ever did couldn't have been recorded. There was nothing that I ever did that I
Why not?
I wouldn't have cared if there was an eye in the sky over me.
So
I
what's
don't know
the
about a
problem
reality
here?
TV show in the back.
Yeah.
But it lends itself to different obstacles and different dilemmas having a television crew with you. But I had no problem with anything being taped ever.
Right.
And most cops don't.
So why are they using their written
maybe you're doing
statements?
something and maybe police work isn't for you.
Right, so then why not admit the videotape of a person confessing rather than having Tom Ruskin write notes about what the person's saying and now you're questioned as to whether your notes are accurate?
Well, I'm going
It
to
should happen every time.
I'm going to be questioned as the officer or the person who interrogated him anyway. If my questioning then comes into question, then you can go to the videotape. But I'm going to have to at least admit the videotape into evidence as part of our business records that day.
Right, exactly. But then you don't have to be interrogated yourself over how great your memory is and whether this person actually waived their rights. I mean, when somebody waives their rights, isn't it more effective if they're waiving their rights verbally on camera than if they're telling you they waive it, you're writing it, and then you're questioned on it?
Especially if they claim deprived or depraved depraved knowledge of what you were telling them. If you see it in real time of what I questioned them and the person says, yeah, I know that, and reads you their rights themselves, even though you go through it again, and then signs the waiver that they've been read their Miranda and thereby waive their right to all the things that they're entitled to, and then they claim in court, oh, I didn't understand. And you see the videotape, yes, it's a very good point. You can basically make your case even stronger.
Right. So we just finished up the Dalia Dippolito hearing, and now the judge has reserved the right to issue his decision, and he will give a written order. So that's over. So, Ron, they brought up all these points that they put into their motion, essentially, saying that she should be freed because she's not a flight risk. She had been already released on bail the first time when her conviction was thrown out. And basically, she has a lot of arguments on appeal that they believe are debatable arguments. I didn't really see anywhere in there that this woman tried to have her husband killed. She's been through this for years. Do you think that there's any other risks that they should take into account?
Yeah, I mean, there's a lot to take into account here. Yes, okay, so they didn't specifically mention the nature of the crime, but you always have to have that on your mind when you're deciding whether or not to let someone out, because the type of person who would try to have their husband killed in a murder for hire plot may also be the type of person who, when they realize that they're not going to win an appeal, is going to bolt. So you have to take all these factors into account in determining, okay, should this person stay in jail after being convicted of this crime or let free to go?
She has a child now. she didn't have a child the first time around. Do you think that impacts whether she's a flight risk? Now she's got somebody that's relying on her, someone to live for, someone to care for, if she has that compassionate side. And so will she try to take the child and maybe go to another country so that she doesn't have to miss 15, 16 years of this child's life?
It's certainly a possibility. If she's, she has this child now, she wants to be there for the child, she's afraid of what might happen if she's away from the child for all this time that she's supposed to be in jail. And yeah, she could very well leave. She's going to try and, hope that this works in her favor by saying, let her be with a child for as long as possible until, when and if she has to serve her sentence. But, I think that it would also work against her because it's evidence, or it's a factor to weigh in to consider that maybe she will leave.
She also chose to have the child while this was pending. It wasn't.
Yeah, what do you think about that,
It wasn't. You don't want to know what I think, but it's not like she was pregnant when the crime was committed. She decided, knowing that these charges are pending against her, maybe to try and have the court have sympathy on her and or the jury have sympathy on her now that she's got a child, and bring that into evidence. It shouldn't weigh at all. I'm sorry for the child, I really am. Hopefully the child has a good 15, 20 years without mommy being around and will be a very productive member of our society. But it's not the court's right to even take that into consideration anymore.
It's very tragic, and there's always the possibility, like you were alluding to and talking about, that she had this child because maybe she thought it would elicit sympathy. I'm not saying she necessarily did it, but there's always that possibility that maybe she thought, if I have a child, my sentence may not be as harsh. Like in this instance, I'll be able to go home while I appeal, things like that. Or maybe she just had the child because she was with someone she loves, and it's a loved child.
Someone who wants to commit murder is not short of having a child to try and drum up sympathy.
It's not beyond a person like that.
And also think about what actually happened in this crime. This isn't an attempted murder in the sense that she picked up a knife and tried to stab her husband. This was a calculated plot, coordinating details, making payments to try to orchestrate this murder for hire. So this is someone who has already been convicted of a crime that involves cold calculation to set up a chain of events. So it's not beyond reason to think that she would calculate a move to have a child, while awaiting a sentence in order, to, get leniency.
I think that's a phenomenal point. I mean, again, we're looking at this crime specifically, and it's not like during a domestic dispute, she picked up the knife, she smacked him with a plate, he went down, and there's mitigating circumstance. There's a woman who said, I'm going to kill my husband.
It was calculated.
Well, it was premeditated, yeah,
Cold, calculated.
It was cold, calculated.
What I'm getting at is she's a schemer, so it's not beyond her.
Well, she's a murderer.
But she didn't actually commit the murder. You're going to call her a murderer?
Yes, I will.
Okay, I'll say an alleged.
Okay, I'll
I'm
say.
a lawyer.
I'll say.
Ron's on my side with that. Alleged.
It's definitely an alleged murderer. But let me tell you something. Had that person been a hitman, her husband would have been dead. So she then would have been a murderer. No, she's an alleged. She's not alleged murder. She's been charged.
Yeah. Well, you're
with
right.
Murder.
It
She's
flows.
been charged with attempted murder.
Well, it flows because
so she's been convicted.
Had he been
so
killed,
she's no longer alleged.
Right.
She is an attempted murderess.
Attempted murderer. But you're saying that legally, and he's right, if she had been convicted and he had gone through with the plot and he was killed, just because she planned it, she would still be liable for the murder, so she would be called a murderer at that point had that happened.
She would have been conspiracy.
A conspiracy, exactly.
She also would have been charged with conspiracy to commit murder.
And you're liable for the offense, the main offense.
Only because she was a shitty murderer.
Bleep.
That would be she was a lousy murderer.
Lousy's very
that
nice.
She didn't know who to pick to commit the murder. Thank God that he's alive today.
Right. You know what? We have some breaking news, actually, thanks to Kathy, who is our trial expert here at Law News. Breaking news out of WPBF reporter Terry Parker, saying that we now know the identity of Dalia Dippolito's love child's father. Isn't this fascinating? Robert Davis, a felon who has been convicted allegedly of battery, grand theft as recently as 6 years ago, and allegedly lives with Dalia Dippolito and her mother, is allegedly the father of Dalia Dippolito's child that she had on house arrest, according to Terry Parker of WPBF. Did I cover all my bases there?
Yeah, that's definitely alleged.
But for our Dalia Dippolito fans here, this is big breaking news.
No, this is a reality show in and of itself.
Still going on.
But it's not a reality show because of what the cops did. It's a reality show because her life is that type of life.
Well, it's drama. I mean, if you're going to be on house arrest and you're going through your third trial and you have a child, it's drama, right? It's another layer to this story.
Definitely makes it more interesting.
I was pushing Tom before because I was trying to get Tom to talk about whether he thinks it's just. If somebody like Dalia Dippolito is convicted, like she was the first time around, on the solicitation to murder charge, all the elements of the statute are met. She solicited someone, she paid them, he gave her the pictures of her husband, did it all, caught red-handed. It's overturned on a technicality, a procedural error. Is that the way it should be in our justice system, that if one of the jurors knew something that they shouldn't, that the whole conviction gets thrown out? We have to go through this all over again.
You have I'm probably in the minority relative to police work, where I believe that if there's a technicality, the person should be able to have due process and have their case reheard. I believe that our system is based on checks and balances in our legal system, and you have a right of being presumed innocent until proven guilty by a jury of our peers. And if there's some problem or something comes up that the person possibly wasn't properly tried and convicted, then I believe that they have a right to I personally believe that they have a right to a retrial. I believe that we have to make sure that everyone in our prison systems and everyone that's convicted is guilty of the crime. And I am sure that there are people in prison that have been wrongfully convicted.
Yeah, it happens, but you know what? So here's the catch-22. You're talking about doing something like that, right, Ron? So that we can avoid, the purpose is really to avoid wrongful convictions. We know it's not going to be a wrongful conviction because we saw the videotaped evidence. All the evidence was there. So does that defeat going down that avenue of giving somebody another retrial on a technicality when we know there's no way this is a wrongful conviction? Because what happens, and what did happen, is that in that second trial, you got a whole new set of jurors, and there was a mistrial. So now you're opening yourself up to actually free somebody that was caught red-handed because of that procedural error the first time, which really doesn't matter in a case like this.
Well, you say it doesn't matter in a case like this, and I may say it doesn't matter, and you may say it doesn't matter, but we weren't the jurors. We're not the ones deciding this case. We didn't decide the case. So if the people who were deciding the case were tainted in any way, shape, or form, then yeah, that's a technicality where it should potentially be overturned if that was the case. I'm with Tom on this one. We have a system put in place to hopefully prevent unjust convictions as much as possible. And yes, we all believe that this was a proper conviction, and I think we probably agree that she's not going to win on appeal, but if she does, then she does. And I'm a firm believer, even as a former prosecutor, that you go by the book, you go by the laws, and if that means letting someone who actually committed a crime go free on a technicality, it's worth it to prevent innocent people from being put in jail unjustly.
I'm not sure I want to let him go.
Okay, go ahead, go at him.
Give him a retrial is a different story.
Right.
What happens, are we judging this case when we're having this argument back and forth, which is a very interesting argument? Are we judging this case by the potential sentence of 15 years? What happens if it was a death penalty case?
Right.
And there was a technicality made during the trial which potentially could put someone who was innocent to death for a crime that they may not have committed. We should overlook it because it was a small technicality? No. Our system is you have to be convicted, and you have to play by the rules, and you have to be convicted by the rules. If something's shown that someone lied on the stand, and or that there was evidence presented that didn't have to do with this case, or was thrown in, or was manufactured, the person has a right to retrial.
But it works in the reverse too, where initially in the first trial, you know, they couldn't bring in this evidence that she was it was the first or the second, they couldn't bring in the evidence that she tried to poison her husband. So it works in the reverse too, where sometimes things are not admissible that should be, and guess what? The prosecution appeals, they do not win on that technicality.
But that's what, I mean...
It's not always fair. The appeals process doesn't come out with a just result.
Prosecutors do. This is what the prosecutors are paid, much more than cops are. And this is the reason that they're paid much. Oh, loads.
Ron would beg to differ as he prepares for his wedding.
This is what prosecutors do every single day in different prosecutions and different courts around this country. And they have to make these tough decisions. Do I bring this in? Is this exculpatory? And all those decisions, sometimes with cops, sometimes with themselves and other attorneys in their office and their bureau chiefs, and that's where these decisions are made, and that's why they're made, and they have a right. I think anyone has a right to second guess those decisions. And did the person get a fair trial because that decision was made? I think that's fair.
Ron, you agree with that?
I do. I agree. I mean, you know, you have these decisions made by people who analyze the situations, and you know, the chips fall where they may.
So we're going to toss really quick in a little bit to some footage from the Gasper trial out of Cleveland, Ohio. And this is basically a man who had a little history of some run-ins with the law. He was apparently some sort of a drug addict, and so he was on methadone to treat a alleged heroin habit. What happens? Well, he's on the highway and he's allegedly speeding. There's a little bit of dispute about how fast he was going. Somebody in front of him slows down, he swerves out of the way and ends up hitting and killing a state trooper. Well, now he's on trial up on aggravated vehicular homicide, DUI charges, and we were debating this before, and I just want to get back to that debate because the question that I had asked both of you, and it turned into a really interesting discussion, is methadone. Is that a controlled substance, first of all, where you could be found not only guilty of the DUI, but it's an element of aggravated vehicular homicide. You can be found guilty on that charge if you are driving under the influence, and that's all you need to meet to get a conviction. Is it a controlled substance, Tom? Yes.
You can't, it's not an over-the-counter drug. It's given by prescription, and it's given by a doctor.
Okay, Ron.
Yeah, I mean, you have controlled substances, you have drugs that can cause impairment, and whether it's for treatment or not, if you are impaired, then that's a crime. You look at what happened with Tiger Woods. You know, he was arrested for DUI, wasn't for alcohol, it was for pain medication, and we saw police video showing how he certainly appeared to be impaired, and now he's gonna looks like he's taking a deal for reckless driving conviction and treatment instead of a DUI conviction. But yeah, if you're impaired by a drug, even if you had it legally, that's a problem. However, in the Gasper case, he took methadone 14 minutes before the accident. Looks bad, but does methadone have the effect of impairing someone's ability to drive? The doctor who prescribed it to him said no, it doesn't. He said that there are studies about this that show that you can have methadone treatment and drive. He, as a doctor, he wouldn't conclusively say that it could never happen, but he said in his estimation, no, it wouldn't impair your ability to drive. Now, countering that, you have the responding officers who spoke to Gasper after the crash, who found that he had constricted pupils and was talking slowly and was confused when they were questioning him and had some trouble following directions during a field sobriety test, which he ultimately technically passed. So there is an issue as to whether he was impaired. Personally, I don't think there's enough to convict him on the impairment.
And what we were talking about before is you need to prove impairment, And you can even do it when somebody has exceeded the limit of alcohol that they're supposed to have, right? You were saying?
Right. With alcohol, it's easier because we have a legal limit. So even if you have a bunch of drinks and then you get behind the wheel of a car and you're pulled over and you blow a .08 or higher in New York and a lot of states, even if you're not showing any sign of impairment, you're above the legal limit, DWI.
It's per se on its face.
Per se on its face, driving while under the influence because you're above the legal limit. That being said, if you're below the limit, but you're showing signs of impairment, then that could be problematic because if you do have alcohol in your system and you're slurring your speech and you're driving all over the place and there's other evidence, that could be problematic. But with drugs, it's like methadone, we don't have that .08 where you could just take a blood test or a urine test and say, oh, he's over the limit, whether his speech was slurred or not, whether he was impaired or not. Here you just have to go with what the doctor was saying could be possible and what the cops say happened.
Right, and so Tom, as a law enforcement officer, when you pull somebody over, right, and you think that maybe they're driving under the influence, when there's alcohol and you smell it or you see it, there are protocols. Basically what? You're gonna have them ask them whether they'll do the breathalyzer, walk in a straight line, touch your finger to your nose. But with all of these new classes of drugs, because there are hundreds of prescription drugs, now you have methadone, we don't know a lot about it. What creates impairment, what doesn't? How do you test on the side of the road at that moment when you know that that's the highest likelihood you're going to get your evidence that there was an impairment? How do you even test for impairment then?
Well, there's different officers who are trained to test for impairment. I was not one of those officers as a patrol officer who could make that determination unless the person's like all over the road and they're either what they call stroking, they're having a stroke, or they're impaired. You pull them over, you question them, they're slurring their speech, they smell of alcohol, there's a bottle of alcohol all over the front of the car that they tried to throw away. I have then enough evidence to potentially take their rights away, place them under arrest. I have that right. And then go through the patrol guide procedures in New York City of calling or taking them to an appropriate precinct to have them field sobriety test and or breathalyzed or taken to a hospital to draw blood.
They don't have to submit to the breathalyzer test. Do they have to submit to the blood test?
You would speak to a DA. DA. That's when you wake up, your friendly DA, and you say, "This is what I'm going to do," and they say, "Go ahead. This is what I got." Or you call the legal bureau. But yes, you can take them to a hospital and you can have blood drawn if you have reasonable grounds. I mean, everything is based on what a reasonable person would do in the same circumstance. Forget about the badge. Forget about the gun. What would a reasonable person do? Being put in the same situation due to this person that they've taken their rights away.
Right, but then how do you, like I said before, how do you test for impairment with controlled substances like prescription drugs?
It's much more difficult. There's
Is it
much
just
more
a
of a burden
visual
on the police
inspection?
department. Yes. Yeah.
Pretty much, right?
Yeah,
You're writing
I
down
mean,
what you see.
What we would do in New York City, we would call for a highway unit. The highway cops are specially trained. They have the advanced training that I didn't have. Maybe some of the patrol officers did, but I didn't have it. And they would respond and they would give what they called the field sobriety test. And then based on that, they would drum it up. So what you're doing is you're putting different notches in a belt to give a DA a pretty airtight case on what they have. So you give a field sobriety test, the person's all over the place.
Like Tiger Woods, all over the place.
Like Tiger Woods.
The guy's a mess.
Yeah. His wife is taking, a 9-iron to the car. He's driven down the street. He's hit a pole. You're the responding officer, and he's all over the place. And you give him a field sobriety test. Then you either could give him a breathalyzer. If he refuses the breathalyzer, you could potentially draw blood.
And sometimes, like with Tiger Woods, they admit it, that they're on prescription drugs.
Because
they're under the influence of prescription drugs, they don't have the inhibition or the good sense to not implicate themselves.
Right. But again, even by admitting that you're on prescription drugs, that's not enough to say, well, they were impaired by it. With Tiger Woods, we were able to see, and cops were able to see that he was impaired. The guy was, falling asleep, falling all over the place, when he was in the station house. Sometimes regardless, even with drunk driving, regardless of what someone blows in a breathalyzer or if they refuse, you can see just from their behavior. I mean, one of our favorite things to do at the office was to watch the videos of the station house of people who are just arrested of DWI. Sometimes you're lucky and you get someone who's, dropping their pants and urinating in a trash can in the middle of the station house. That happens. But sometimes you don't have that, and you just have to, sometimes it's a little more nuanced. With Gasper, okay, how much was he slurring his speech, if at all? What did his eyes look like? Were they constricted? To what degree? So, he took a field sobriety test. He had to do the finger to nose test, and he was able to pass it, but the officer said, well, he kept his finger there a little too long. It was a little weird how he was doing it. So he passed the test, he didn't pass the test. It's a very nuanced situation there, so it's tough.
It's like if you take up yoga as a hobby, you are more likely to pass these tests of standing on one foot and putting your finger to your nose, even if you're under the influence, than somebody who may just not be as coordinated. We're going to toss really quick to a clip from the closing arguments in the Gasper trial. The big deal here today is that we are on verdict watch for the Gasper trial. So let's take a look at the closing arguments and see if any of the stuff that we were discussing was presented to the jury.
Trooper Velez's death was a tragic accident, and nothing the government has proved to you in the last 2.5 weeks has shown anything different. I understand there are a lot of people hurt by the trooper's death, and I understand that the government has to come up and put on a case. And I understand when this prosecution started, they wanted to let a jury make the decision. What I don't understand is trying to mislead you. What I don't understand is stretching the truth. What I don't understand is a mean-spirited prosecution that's just wrong. It's wrong. It's wrong to stand up here and tell you things that you know aren't true. It's wrong to stand up here and try and imply that Josh wanted to take the berm as a shortcut. That Josh just chose to ride on the berm as if it's something you choose to do. Maybe the cars in front of him were going a little too slow, so he was just going to pass on the berm. You know that's not true. We all know that's not true. Why don't they want you to know what the truth is? Why? Because the truth is, this is an accident. And if you drive on these roads and you are unfortunate enough to hit a police officer, you could be sitting in the same seat as Josh. And they could be coming after you the same way. Why don't they want you to know that there are 3 parties to this accident? There's the trooper, there's Josh, and there's Mr. Sanford in the blue Honda. Why do they shy away from that blue Honda? Their own accident reconstructionist has the blue Honda putting down a skid mark of 30 feet. Why? They know it. Why don't they bring it up? Because it doesn't go with their, oh, Josh is just crazy and careless and likes to pass on the berm. Let's look at what happened here. Let's look at what we know. We know Trooper Velez is a good man. We know he's getting ready to retire. We know he's a hero. He's out there. He's doing roadside enforcement, but he's standing outside of his car. And no matter what they say, and no matter what the Highway Patrol authorizes, that is dangerous. It's dangerous to stand outside your car on the highway. It's just dangerous. They've changed their policy now to put an orange vest on him. That didn't exist at the time. But I don't care what they put on him. People don't belong walking in that highway if it can be avoided. But Trooper Velez had a job to do, and he's out there, and he is using these pan methods to point people down. But let's get what he's really trying to do. There's nothing wrong with it, but he's trying to surprise folks and catch them speeding. He's not there as a warning. He's not there to tell you to slow down. He doesn't want you to see him. How's he going to catch you speeding otherwise? We know he doesn't want you to see him because people didn't see him. How do we know they didn't see him? Because they all hit the brake lights. We heard from witnesses that the whole crowd hit the brake lights. This is not a situation where you see a police officer 2 miles down the road and you just barrel right on through. Watch the video. Nobody was getting out of that left lane. That left lane was full of cars. This isn't lowering sights, pull to the right type situation. He was there with his gun catching you. And lights were lighting up as everybody went, there's a cop. But his signals, for whatever reason that day, weren't making sense. They weren't being understood. How do we know that? Because all the eyewitnesses thought they were getting pulled over. How many eyewitnesses came in here and said, I didn't know if he was talking to me. I didn't know if he was talking to me. I didn't know if he was talking to me. Confusion. Confusion is deadly when you're standing on the side of the road trying to direct 4,000-pound vehicles. It's deadly. And there was confusion. Mr. Sanford. Confusion. What Mr. Sanford did, I can't say it's not reasonable. How many of us have been driving along and all of a sudden had a police officer out in front of us giving him some type of signal? What's he saying? Is he saying to stop? Is it safe to go on? Am I in trouble? Are my wheels on fire? What's happening? Mr. Sanford didn't do what he was expected to do and go, I'm getting a ticket. I'll pull over. Mr. Sanford hit the brakes, locked him up. 30-foot skid mark. We see it. We can see him slam on the brakes right in front of Josh. 30-foot skid mark. That's the risk when there's confusion out there. That's the risk of this kind of enforcement. Maybe some of you experienced drivers say, you understood that, but put a young person out there, put someone who's nervous out there. It's dangerous. We all know folks who, if a cop jumped out at them in the road and did a hand signal, they wouldn't know what to do. It's dangerous. And Mr. Sanford didn't know what to do, and he slammed on the brakes in the lane of traffic. And that's when Trooper Velez, by all accounts, and I may be wrong on this, but my understanding is he started walking over to Mr. Sanford probably to go, no, burn, move it, because he's 5 feet. He's 5 feet from traffic, and 5 feet can sound like a lot, but 5 feet is from here to there. He's close to traffic. He's walking up, and he's from where I am, this table, and he's saying, I imagine, move over. But it's busy out there. Watch that road. Watch that video. Cars are flying by. No, they're not getting out of the left lane because no one knows that he's there. No one sees the trooper advance. They're not looking way out there and seeing him. He's surprising them. Put yourself in Josh's shoes. You're driving, going to work. You're on 90. Nothing crazy's going on. Maybe you're smoking a cigarette. Maybe you're listening to the radio. Maybe you're thinking about the job you're getting ready to go bid on. You're keeping up with traffic. You're not going too fast. You're not going too slow. You're doing what we all do on 90. Next thing you know, the car in front of you slams on its brakes. Slams on its brakes. 30 foot. 30 foot decelerated. 30-foot skid mark. We can look at the video and we can see that the blue Honda landed parallel with the trooper's car. And we can see that Josh shot right around it. What do you do in that situation? You're on 90. It's a busy day. Guy slams on his brakes. By all accounts, these brakes take 190 feet to take you from the point where you're going the speed limit to the point that you're stopped, 190 feet. For the prosecution to suggest you should just hit the magic brake and stop the car, it doesn't work that way. It doesn't work that way. If you don't catch those brake lights the minute they shine in your light, if you're a second delayed, you're going to smash right into the car in front of you. So those are Josh's choices. Do I smash this car in front of me, which I'm about to do? We've all been there. We've all been there. When you're in traffic and all of a sudden someone stops in front of you, maybe not to the degree this happened, maybe not at this speed, but we've been there. You look in your rearview mirror and hope no one's going to hit you from behind, or you start doing those mental calculations that you don't even know you're doing to try and figure out how to save this accident from happening. And as a reflex, I know there's traffic to the right of me. I know that. I know I'm going to hit this car in front of me. Emergency lane. What do? You head for the berm. You head for the emergency lane. That makes sense. That's your only chance. Your only chance is to hit that berm and try and slow down in the emergency lane and not make contact with anybody. And 99 times out of 100, 999 times out of 1,000, out of a million, that's the right move.
Objection. Sustained.
Who would think that on that particular day there would be someone standing in that berm? Who would think that? Who would think that that highway patrolman would be there on that particular day when your mind makes that split-second decision to try and avoid an accident? Next thing you know, you're on the berm, you're locked up, and you're skidding. And you go 190 feet and 55 feet into the skid, you hit the trooper. You manage to avoid the car in front of you. You manage to get your car between a 10-foot space between the two cars, the trooper's car, and the Honda. You hit that in that 3.9 seconds it took from start to finish of this whole event. You make the right moves. But 50 seconds in, there's a trooper standing right by his car. Trooper wearing all gray. Trooper you didn't see. And now you've hit him. And now you stop. And now you're in shock. And now you get out of your car, and there's nothing you can do. And you're wondering what's going to happen next and what's the right move, and you look at the trooper and it's clear that he's in bad, bad shape. And people are jumping out of their cars, and you stay there, and you don't know what to do. Maybe you call your mom.
Sustained.
Josh stayed there. Doesn't know what to do.
Objection. I would ask the court caution, counsel.
You're not testifying. The jury will remember the testimony. It's the evidence, not what our opinion of the evidence.
We know that Josh got out of his car. We know that Josh stayed at the scene. We know that Josh watched as aid was rendered to the trooper. We saw the big pool of blood. We saw that. Josh was right there for it. Then people start coming up to him. People start saying things to him. Some lady comes up and accuses him of being on something when he's not.
Objection.
Still, Josh stays. No one's being nice. There's no testimony that anyone's coming up and saying, don't worry, it's okay. It'll work out. He's out there alone. Next thing you know, a man wearing the same uniform as the man he just hit asked him to start doing some tests. Want to think about Josh's state of mind? Josh was high, or Josh was drunk. What do you think his response would have been when the troopers tried to take him behind somewhere away from the cameras? The trooper said, hey, let's take you away from all these cameras that are set up here. Let's go somewhere where you won't be on the nightly news. Josh said, no. I want to be in front of as many cameras as I can be. Who does that? Who wants proof? Somebody who's not impaired. Somebody who's not drunk. Josh wanted proof. Think about his state of mind. Next thing you know, these officers have given you some tests, and you do fine, and you do fine, and finally you tell them your knees are shaking, you tell them you're scared. Finally, they give you a test, and the very last test after you pass them all, when you're so scared, they ask you to put your left hand on your nose and your right hand on your nose, and you get them wrong. You put your right hand for your left and your left hand for your right, and it takes about 30 seconds before you go, oh, I'm sorry. That's enough. That's it. You're locked up, you're arrested, and for the next 11 months, people call you a cop killer. And people say you were high on drugs, and that you were drunk, that you were speeding. And it takes 11 months before you finally get someone to come in and say, Listen to the evidence. That's not what happened. This was an accident. This was an accident. The state of Ohio has thrown every...
Oh, that was a good place to stop. This was an accident. This was an accident. That was basically the defense's theory in the Joshua Gasper trial, which we are on verdict watch for today. This was a man in Cleveland, Ohio, who had taken a little bit of methadone to treat his heroin habit and ended up going faster than he should have on the highway, swerving and right into a state trooper. Joined again by Ronn Blitzer, an editor here at Law News Network and a former prosecutor in the Brooklyn DA's office, and Tom Ruskin, a private investigator who served more than 20 years with the NYPD. This is the big controversy here for me with this case. I agree with the defense that officers, law enforcement officers, should not be pulling people over on the side of a busy highway where there are Mack trucks and all of these cars, there are children in cars and things like that. Why, Tom, are they on the side of a busy highway instead of pulling somebody off of an exit?
Because that's where you have committed your violation. Cops over the years have refined their pulling over or their stopping techniques to basically safeguard the person that they're pulling over.
And themselves,
as well as
though.
themselves.
Right.
So they normally look for an area before they light up their, what they call lighting up their car, turn on their overhead lights, which is going to make you pull over. They normally know, if a cop is familiar with an area, he knows the area in which to stop you. And they look to do that. They've also refined their approach techniques. Now, a lot of days, the troopers or highway cops approach on the passenger side to give them more protection as well as a better advantage on how to approach the driver should the drivers have some ill intent towards them.
Now, what about, though, in this case where you have the state trooper and, God bless him, may he rest in peace, and we're very sorry for his family, but just to talk about this issue for a second, where you have the state trooper, it's almost like he's hanging out over there to do some sort of procedure protocol, maybe to help somebody who was swerving, things like that. He's not even pulling somebody over and focused on giving them a ticket. He's there for a prolonged period of time on the side of a busy highway. Is there contributory negligence here? Tom, really quickly, you know what that term means.
You're talking about civilly or criminally? Criminally,
to mitigate the charges here that he may have contributed, or maybe the police department may have contributed by putting him in this scenario that created a dangerous situation.
Possibly, and that's what the jury will decide. But I will say this, it's from cases like this that procedures and techniques are changed to better protect police officers.
Right, and so Ron, really quick on that, because legally, it's a valid argument if you're going to, let's say, run in the middle of the road and somebody hits you. I mean, this obviously is different, but if that's the scenario, a lot of times the person that hits you, it's deemed an accident, and that's what the defense is saying, that this was an accident because he was just 5 feet away from this highway.
Listen, normally I'm not a big fan of blaming a dead person for what led to his death.
No, God forbid, and we're not doing that here. I just want to be clear.
No, I'm not saying that.
But for argument's sake, we're saying, did he contribute to the dangerous situation? Not necessarily that this other guy didn't kill him because he was reckless, but was there a contributory factor?
I'm saying that the defense is using the argument that the officer's own actions led to this situation. And while normally I don't like that approach, I think it is a very valid point in this particular situation. I think it's the best argument the defense has because it eliminates or tries to eliminate methadone from this, impairment, any wrongdoing by the defendant, and says, look, the officer wasn't wrong to do this. He's doing his job. He's doing it the best way he can. But it's a dangerous situation, and someone in Gasper's position could end up killing an officer, whether they're impaired or not, whether they're doing anything wrong or not. It's a dangerous situation. Accidents can happen, and this is what happened here.
Right, so essentially it shifts the focus and brings up a valid point. Tom Ruskin has to go, so thank you so much for joining us. Really appreciate it, and you brought a lot of great insight, knowledge, and experience to the discussion. Thank you. And so now we're going to toss really quick to the prosecution's closing in the Gasper trial, because we are on verdict watch, and let's see if the prosecution proposes as passionate of an argument as the defense did, because he was quite good.
All right, so I've had a chance to go back and reread State versus Richardson, and I stopped there because it is a recent Supreme Court decision from December 29, 2016. I'm not aware of anything more recent. The parties haven't presented anything more recent. And paragraph 14 seems to be dispositive of the issues that the court raised. And that was the statutory interpretation of this phrase, 4506.01M, drug of abuse. So in paragraph 14 in Richardson, the Supreme Court references that. They give the definition of drug of abuse. Then they refer to and quote the section specifically means any controlled substance, dangerous drug as defined in section 4729.01 of the revised code, or over-the-counter medication that, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. Then they go on to talk about 4729.01F, and they also cite to revised codes section 371941 that puts hydrocodone in the Schedule 2 list. Then their comment, or their holding is, distilled for our purposes, those statutes say one thing, hydrocodone is a drug of abuse. So the fact that hydrocodone was a controlled substance and also fit into dangerous drug, for them seemed to be dispositive of the issue of what constitutes a drug of abuse. And we're in the same situation here. Methadone is a Schedule 2 drug. It's a controlled substance. So I think I'm constrained by the Supreme Court's decision, guided and constrained. So count 5 then will be amended so that it reads, did operate any vehicle, streetcar, or trackless trolley within the state, but at the time of the operation it was under the influence of a drug of abuse, to wit, methadone. I think that that's what the present state of Ohio law is. So the motion for judgment of acquittal on Rule 29 on that narrow issue that we talked about is denied, and it's also denied on counts 1 and 3 then because they require an underlying finding of driving under the influence.
Respectfully note my objection, sir.
Yes, thank you. And it's an issue that they dispose of in one paragraph, and at some point they may review that section differently. I don't know, but that's how they've read it most recently in the Ohio Supreme Court. Any argument upon anything, any of the other counsel that I've asked you, but anything you thought of while I've been out?
No, Your Honor.
Driving in the berm of a highway, that's not an accident. That's a conscious decision. Following too closely behind a car, that's not an accident. That's a conscious decision. Taking your dose of methadone at 12:34 p.m. at East 55th and Euclid Avenue in Cleveland, Ohio, and making it to I-90 westbound at the Cleveland and Lakewood border to strike and kill Trooper Kenneth Velez at 12:44 p.m. 10 minutes later. Throughout this trial, you've heard testimony and evidence about decisions that this defendant made on September 15th of 2016. Not accidents, not missteps, but conscious decisions every step of the way. That's what this case is about. This case is about the choices he made. The fact that the defendant disregarded everything else and did whatever he wanted to do. Alabama said your license is suspended. This defendant came up to Ohio, tried to get a license here. Somebody was driving too slow on the highway. This defendant got right up on their tail. And when that person started to slow down, this defendant didn't. What did he do? He drove inside the berm of a highway. That's not an accident, that's a decision you make. See, when most of us drive off in the berm of the highway, it's to change a flat tire because there's an issue with our car, or something is going on that would justify that. It's not because we're speeding down the highway. It's not because somebody else sees law enforcement and properly stops. But that's what this defendant did. Instead of making sure he had enough distance on that road to stop and do the right thing, he said, forget it. I'm just going to drive in the berm. I'm not going to slow down, not going to stop, not going to follow any laws that apply to the roadway. I'm going to drive in that berm. And when he made the conscious decision to drive in that berm, after taking his methadone 10 minutes before, he killed someone who was on the berm doing their job. That's not an accident. That's a decision to do whatever you want to do on that day. That's a decision to disregard, to show reckless and heedless indifference to what our laws are. That is the action this defendant undertook. And so let's walk through the counts and talk about the evidence you have to support each and every count. Well, when we look at count one, let's be honest. Nobody's disputing that the defendant was driving that day. You heard multiple witnesses come in and testify. Yeah, we all saw the defendant driving that day. That's not in dispute. No one's disputing the fact that this defendant striking Trooper Velez was the cause of his death. That's not in dispute. And so what really is in dispute in this case? Well, there's an argument that they're trying to say, well, maybe the defendant wasn't actually impaired. And so you have to go back and look at the evidence. What do you have to show you that, in fact, the defendant was impaired? And as the judge said, he's going to give you the law, but we're going to talk about it a bit. No person shall operate any vehicle at the time of operation. The person is under the influence of alcohol, a drug of abuse, or a combination thereof. Methadone is a drug of abuse. The judge will tell you that in your jury instructions. So there's no question that the defendant was driving his car. There's no question that the defendant had taken a drug of abuse 10 minutes before he struck and killed Trooper Velez. Recall the testimony that you received. 12:34, you see the video of this defendant taking his methadone. 12:34 p.m. By 12:44 p.m., he struck Trooper Velez on 90 westbound. And what else do you have to show that this defendant was impaired? Well, you have the observation of professionals on the scene who just stopped to help. Remember, at the beginning of this trial, we had those innocent bystanders who came in and spoke with you. And they spoke with you about why they stopped and what their observations were. And what their observations of the defendant were. And why, even as normal people responding to the scene, they had concerns that this defendant was impaired. And then you have Sergeant Gable's testimony. And he went through extensively in experience, his 16 years on the force, all his certifications, the fact that he is an instructor in these courses now. And he walked you through step by step what made him think this defendant was impaired. So let's talk about, first, what those lay witnesses saw. The people who were driving on the same highway as the defendant, but they didn't drive in the berm and kill anybody. It starts off with Trooper K, who saw the crash on the road, stopped to assist, and said his observations of the defendant was he was emotionless. And there were no visible signs of distress from the defendant as Trooper K sat there and observed him. You have Jonathan Arroyo, who testified, and he says he saw the officer as he was going over the hill, and that the defendant was talking, but he wasn't making any sense when he was talking. You know, just the fact that he said he looked down for 1 second, and then when he looked up, the officer was just there. That kind of just didn't sit right with me. Mr. Royal said the defendant was slurring his words. This was somebody else who was on that highway, driving, but didn't make the conscious decision to drive in the berm like the defendant did. And then you had Dr. Keegan Conroy, who talked extensively about his observations of the defendant. He talked about the defendant not doing what everyone else did. And in fact, we took down a couple of his quotes because they were so significant. He was asked about whether or not he didn't note the actions of the other vehicles by defense counsel. And his response was, I think I did not mark their actions because their actions were consistent with everyone else, whereas the Blasters' actions were considerably different. Everyone else on the road that day obeyed the laws. Everyone else slowed down. Everyone else did not drive in the berm and kill someone, but the defendant did. The doctor went on to say he didn't slow to meet the pace of traffic. He rather kind of came up on the car in front of him quickly, then swerved into the left lane rather than just slowing and staying. That's a conscious decision. When you decide that I'm not going to slow down, I'm just going to go around this car by driving in the berm, that's not an accident. That's a decision that you make. The doctor went on to be asked, well, what adjective would you use to describe the velocity's reaction to slowing traffic? And he said, I thought it was inappropriate. He was driving inappropriately fast relative to the other traffic. So what other observations do we have? Well, we have the Homeland Security officer, Officer Dalia, who again described the defendant as having an apathetic demeanor. And then you have Anthony McGraw, who came in here and was the EMT who was also driving on that highway, responding to that scene. He walked you through carefully every step he took to try to assist Trooper Kenneth Velez. And then after he assisted Trooper Velez, he told you that he remained on scene. And he told you as well about some of his observations of the defendant. And he said, the defendant was out of sorts, distracted while speaking, anxious and a bit confused. He said he seemed unnatural, like he was under the influence of something. And Anthony McGraw was so concerned about that he told you, I made sure I stayed on scene and told law enforcement that I had concerns about whether or not this defendant was under the influence. He made that point very clear. He didn't do the standardized field sobriety test, but he did say he was heavily trained in drug impairment. That's part of his job as an EMT. He walked you through that. He has to deal with overdose people and things of that nature. He says, I have training in this field. And based on my observations, I had concerns that this defendant was impaired. And then you have Mr. Sanford, who again said, he slowed down. He didn't hit anybody. He didn't drive illegally in the berm. When he safely could, he got over. And so what else do you have? Well, we have Mr. Wachowski, who said people were slowing and then he heard the sounds of the crash. We had Gene Fitch, who again observed the defendant. And why do we keep going back to the fact that the defendant didn't have any injuries? Well, there were some injuries to his hand, but there kept becoming these questions. Well, maybe he hit his head, maybe he did that. That's not evidence. That wasn't the testimony that was in front of you. The testimony that was in front of you was that the only visible injury observed to this defendant was something to his hand. That's it. And so you can't conjecture and speculate on something that's not evidence. And the evidence is the only injury to this defendant was his hand. And then you had Jenny Peacher come in and testify. 40 years of experience as a nurse. She told you her observations from the scene. And she told you that she was so concerned about the defendant. She observed the constricted pupil. She had such concerns about his impairment that she flat out asked him, are you on something? Not only did she relay her concerns to law enforcement, but she asked the defendant That's how certain she was based on her training experience, that there was some sort of impairment going on with the defendant. And she said, what are you on? You look like you're on something. Are you taking drugs? That was what she asked this defendant. And then we have Sergeant Gable's testimony. And he walked you through, step by step, the totality of the circumstances that he observed in drawing his conclusions. And he talked to you about the constricted pupils that he noted on the defendant. He explained to you that the defendant spoke in a low, raspy voice. He said the defendant seemed confused. He had to repeat his instructions over and over and over again. The defendant still asked questions about the instructions he had just been given. He talked to you about the fact that the defendant volunteered that he was in a methadone program. So at this point, we knew the defendant was on a drug abuse because the defendant disclosed that to the officer. He talked about the presence of a lack of convergence and the obvious leg and body tremors on the defendant. And then he walked us through each and every test he gave this defendant, trying to confirm or negate all the suspicions of impairment. And before he even got to the test, I think it's important to note that Sergeant Gable said, hey, I need to observe this guy before I even ran him through tests. I wasn't trying to jump to any conclusions. I wanted to do a thorough investigation, so I observed him. And at the point that I observed all these warning signs, it was then that I said, yes, we're going to administer the standardized field sobriety test. And so he did. On the walk and turn, the defendant had obvious leg and body tremors. He stepped off the line during step 4. He failed to touch heel to toe on step 7 and 8. After step 9, Sergeant Gable went through extensively. I didn't necessarily count that as a cue because he didn't quite put his foot down as he was taking that 10th step. But he did begin to take that 10th step. And then he talked to you about the turn that the defendant did. The sergeant stepped off the stand and demonstrated to you, these are the instructions I give before I administer this test. I tell the individual, keep one foot planted and turn, taking a series of small steps. And then you saw in the video that he gave the exact same instructions he told you he had. And you also saw in the video that the defendant did not follow those instructions. He did not turn with a series of small steps, rather he took one large step and did another small step.
That was the prosecution's start of their closing argument in the Joshua Gasper trial in Cleveland, Ohio. Again, this was a person who had a history, run-ins with the law, potential drug abuse and addiction, was on methadone while driving on a highway in Cleveland, Ohio, presumably to treat some sort of a heroin addiction. And what happens? Well, he's going a little bit too fast, swerves out of the way, and ends up hitting and killing a state trooper who's on the side of the road, doing some sort of an enforcement check. So I want to now talk to Ronn Blitzer, who is the editor here at Law News, one of the editors, and he's also former prosecutor at the Brooklyn District Attorney's Office. Were you on that reality show, Brooklyn DA, just out of curiosity?
No, but I knew pretty much everyone who was.
You know what? I heard that it really messed up some cases. I don't know if you can talk on that. Do you have? Are you under an immunity clause or something like that?
So that show aired after I left.
Oh, okay.
So no, I'm not.
What do you think of something like that before we get to the topics? Reality show. Does it interfere with cases? Can it result in something being thrown out?
Well, I thought it was more interesting just because it was during an election season at the time. So there was a lot of controversy over whether it should be allowed as, you know, a campaign material, possibly. The DA ended up losing that election, I think. But yeah, it was interesting to see my former coworkers on television.
Okay, so were they true to their character, or were they were they putting on a show for the camera?
They seemed to be pretty true. The nature of the work, I think, was glamorized a tad.
So let's get back to business here. The Law News Network, the Gasper trial. What didn't you like about the prosecution's argument? Because we summarized basically the theories of the case. Prosecution saying he was under the influence, impaired by methadone, and that's what caused this. And the defense saying, no, it was an accident, and the trooper created the dangerous condition by being on the side of the highway. With the prosecution first, what don't you like about what they said?
There was one moment in the prosecution's closing that rubbed me the wrong way. She said, this was not an accident, this was a decision to drive into the side of the road. No, this was a reflex. This was a reaction. You want to say that Gasper shouldn't have been in the position to react that way, fine. You want to say he was impaired by methadone, make that argument as best you can. You want to say he was speeding and that's why he didn't have enough time to react properly, make that argument all you want. But to say he decided to do what he did takes a little too far in my opinion, because it makes it sound like he knew what he was doing and intentionally drove into the side of the road where a cop was, and that just pushes it a little too far. I think when you use hyperbole, when you use overstatements, it undermines the valid points of your case, of which the prosecution here has many. There are a lot of things that they could say that are strong arguments against Gasper. But to say he decided to drive onto the side of the road, no, in his mind, and this is what the defense is saying, in his mind, he had to react quickly, and it was either drive to the side of the road or drive into traffic, because he was trying to avoid the car in front of him. So
okay, so then as a former prosecutor, let me ask you this. Did this nice prosecutor lady in Cleveland, Ohio, did she fall into this quagmire of essentially, she hears the defense saying it's an accident. She feels compelled to go the total opposite side of the spectrum and counter their allegation that it was an accident by saying that it was intentional. Did she fall into that trap? You don't necessarily have to do that in closing. You don't have to go the bipolar opposite.
no, you don't have to go the opposite. In fact, a lot of times agreeing with the opposition can work to your benefit, because you eliminate certain arguments by saying, oh yeah, this was an accident, but it was an accident that was caused by the defendant. So if it were not for the defendant's own actions, this wouldn't have happened. You can still say that, you can still blame the defendant and say this was an accident. You could say his decision was to take methadone. You can say his decision was to speed.
Right.
You can say his decision was to be in a position where he couldn't react safely to the situation.
And what about my favorite argument? If I were a prosecutor or a defense attorney, I would go with this argument every single time. It doesn't matter. That's my favorite argument. It doesn't matter. It's irrelevant. Doesn't matter if this guy caused an accident, if he intended it, because under the statute, all you have to do is meet the elements of the statute. What are those? That either he was under the influence and impaired by this methadone, or he was reckless, and to satisfy that, you've got whether he was speeding or not.
Exactly.
So it doesn't matter.
Exactly. Now, maybe saying this was the decision plays into the recklessness, but again, you don't need that if he was impaired, if he was speeding.
Suspended license.
Suspended license. So you can argue other things to prove that element, to prove recklessness, instead of making it sound like this was a decision that he made to do this.
Right.
No, you say this was a guy who killed an officer because of his own wrongdoing. You don't have to overstate it any more than that.
Right. And so now, how about the defense? We know that this was a very passionate, effective defense attorney, because we all sort of stopped what we were doing and we're totally focused on what he was saying. A lot of times, the more theatrical you are, the more effective you are, right? So what did you like that he said?
I thought that he said that was very effective, was playing this up as an accident, saying, this...
He was simple, right?
Yeah, he said this was a dangerous situation for everyone involved. This was a police activity that inherently has risk to it, and officers know the risks involved. And while, yes, officers are right to enforce the law, things happen.
And sort of questioning, why are they enforcing the law on the side of the highway? Is that a practice that we should continue doing in this country?
And that's a valid question too. You don't want to overstate that question too much, because you don't want to be the bully who attacks the dead person and blames everything on him. But if you attack the situation and say, this was a recipe for disaster, and it just happened to happen to someone who took methadone 14 minutes beforehand, then you can say, okay, this wasn't the defendant's fault. This was circumstances that were unfavorable to everyone.
Would it be out of the realm of possibility for the defendant to sue or propose as a defense or attach to some sort of a civil suit. The police department for creating these protocols that created the dangerous situation. So not blaming the victim, but blaming the practices of the police department for putting people in a dangerous situation.
You can sue if you want to. I wouldn't. If I were the defendant, I would not push my luck to that degree, because you open the door for all these attacks on you again, because they could say, well, you were on methadone, you were doing this, you were doing that.
But is there a legal basis where it wouldn't be a frivolous suit? Could you come up with something?
You could always
contributory negligence, but
you could.
If you're not the victim.
If you're not the victim, I mean, you could. I wouldn't do it.
Mm-hmm.
Yeah.
Okay. Well, thank you so much for joining me. I know you have to get back to work for us here at Law News. So we're going to toss now to another clip from the Gasper trial. We are on Verdict Watch, and we will be returning with the Henry Segura trial in a little while when they come back from their lunch break. But for now, let's go to the defense's closing part 2 in the Gasper trial, where they basically make the claim, listen, this guy should get off on the aggravated vehicular